being taken against you. It simply means a response was not filed. We do this purposely for our clients because in filing a response, that triggers a secondary court fee, which a lot of people are unfamiliar with. Now, we're doing these helpful live videos. We know there's a lot of people out there who are trying to do their own divorce. We are a full service divorce solution, so we'll be happy. We're a paid service. So if you're looking to have someone take over your case, we are happy to do that as well. But we get a lot of people reaching out to us who just don't have the money or capability to retain us. And so we're trying to get some of this helpful information out there. We know it's tough with the courts to get the help, and we're finding out that the help you are getting when people call us is incorrect. In fact, today we had someone call us who said they had filed in 2001, and we get a lot of old cases, and that he went to court and the court told him, well, you should dismiss your case. And that is inaccurate. You don't have to dismiss your case when you have an active case and the court hasn't dismissed them themselves. It's easy to just do a stipulation to agree to continue the case. And the issue is that the courts only give you 5 years to finalize your case. So they can dismiss it unilaterally if they decide to. However, if you agree, you and your spouse, excuse me, to continue the case, you file a stipulation and you can finalize your case on that old case. We've done 25-year-old cases before. I think even 30-year-old cases that were on microfilm. They weren't even, there wasn't even computers back then. They kept them in a book and then on microfilm or microfiche. I forget what they call it. But let's get into the reason we're doing this video today, default with written agreement and what forms are required. So I'm going to start this with the assumption that you have already filed your petition, your proof of service, and even maybe your default. But we, as a practice, we file our default all as one final step. And I can kind of tell you how we do it just to make it easier for yourself and easier for the court. Is we will file the initial summons petition, and if there's children, the UCCJA, get a case number issued, have the spouse sign a notice of acknowledgement instead of having them personally served, and then we hold all final paperwork until the end. You don't have to do it in that particular order, submit the proof of service, and then wait 30 days, and then submit the request in or default. We turn all that in one shot, and what we're finding especially when we're electronically filing with the court in LA County with the judgment, when we submit a full settlement agreement, all the final judgment documents, all at once, including the proof of service, everything after the petition's been filed, we're seeing approvals sometimes in 3 or 4 days. On the outside, a week to a week and a half. So it's very fast because you see, if they're getting everything at once, then they don't have to open up your file and find what's been previously filed. They know only thing that's been filed is the petition. And they get the proof of service, they get the disclosure forms, they get the income and expense declaration, they get the judgment, the default, all the final documents in one shot, and we're getting very, very fast approvals. If you're joining us today, I see a couple of people have hopped on. We're talking about the judgment forms required on default with written agreement cases, which is the type of cases that we handle. We're going to go over the forms. And what we're trying to do is get past the part where you've already filed your petition and your proof of service. And we're going to talk about specifically the judgment with default with written agreement. So this is not where a response was filed. That's considered uncontested. And hey, Kara, I'm glad you made it so you didn't have to kind of go back and watch this. We had some really good questions come over the last few weeks, specifically on this. So I thought instead of just emailing back the responses, it'd be best just to do a video because some of the questions were interesting to me for having done here. See how the questions were asked, that it isn't so obvious, and that's where a lot of these questions come from. So I'm going to rattle off the forms, and I'm going to see if I can share my screen with you. Seems like our internet is not doing so well, even though okay, what's going on there? Give me 1 second. Not sure why that's happening. So anyways, what I wanted to show you is there's a judgment checklist form. It's a FL-182. And this judgment checklist form isn't something that you necessarily need to turn into the court. It's not something that the court would file, but you would use it simply as a checklist for the different types of divorce cases. So while there is default with a written agreement as one option, there is also default with no agreement and uncontested. So it does have all the forms, and it will break it down whether if there's children, you need these additional forms and so forth. So, Kara, I know you're here. I'm glad we're able to do this for you. I'm going to just go down your list of questions after I rattle off the forms that are needed. And then if you have any additional questions, feel free to throw those in the chat. Excuse me. So when it's a default with written agreement, the respondent, even though they haven't responded, you're still called the respondent. You still need to do your disclosure forms. So this would be the 141. It would be the income and expense declaration and the 142 schedule of assets and debts. So the form numbers, I know people like the form numbers. So 141, 150, and 142. And I didn't bring up any of these forms, so I'm going to be doing this all off the top of my head. So it'll be a good test. So you still need to do them, but whether you file them or not depends. And as well as the 142, there's an alternate form you can complete, which is the 160. And this is a question that came up and whether those need to be filed. So the 160s, we've talked until I can't talk anymore, to never file those if you have a amicable divorce. Don't attach them to your petition. Don't attach them to your judgment. They're not necessary. So, Kara, for you, you do not need to complete those 160s. Do not attach them to the 165. So 141, 150, and 142 is the disclosure forms. They're still mandatory. The 141 always gets filed. And one of the questions that came up is whose name goes on the 141 if you haven't responded? It's still it's still your form. So it's not going to be the petitioner's name. If you're signing the form, your name is going to appear at the top, or that form will be rejected. One thing I want to go over that gets missed a lot on that 141 is you only have to do the preliminary declaration disclosure. And let me pull up one of the forms. One of the spaces that people miss all the time is the date the 141 was served. And this is in number 2. So if you're the respondent, you're going to say respondent's preliminary, I am the respondent. And then in box 2, respondent's preliminary declaration disclosure, et cetera, was served on the other party by mail or personal service, and then on date. Everyone misses that, and that'll cause this form to get rejected. So make sure the date's in there. And that's really all you need to complete on this form. Of course, sign and date it at the bottom. And that's how that form is completed. The rest of the judgment forms, let me pull back up the judgment checklist on a default with a written agreement, is going to be, and I'm just going to rattle off the form numbers, the 144, the 170, the 180, the 190, and then your judgment forms. And I want to talk about where people go wrong. There's at a minimum, even if you have no assets and debts, even if you want there to be no alimony, you still need to attach a 343 and a 345 at a minimum. If that's all there is, even if there's no property, again, even if there's no spouse support, you still need to attach those. We'll see people that will retain us who can't get their judgment through, and I'll ask them to send me what they filed. And all they filed was that FL 180, which is basically just a face sheet to let the court know what is behind it. It's not the actual agreement. It's just the face sheet. It's part of the agreement, but just the face sheet. So we're not going to talk about if there's minor children. Specifically, this is if there are no minor children, because there's some additional forms when there are children involved. So again, the forms for the judgment is going to be if you haven't already filed the request enter default, it'll be the 165, the 170, 180, 190, 144. All of those should be prepared in the petitioner's name, not the respondent's name. So it's not really a downside because you're not having to pay the fees by not responding, but all of the forms should be done in the petitioner's name, except of course the individual forms like the 141 that the respondent is going to sign. So the 144, that you will complete as well. That's just saying you're waiving the final declaration of disclosure. You don't have to do a second 141. The 144 takes care of that. So the 170, again, that should be prepared in the petitioner's name. And that's a pretty straightforward straightforward form. And they're just kind of telling the court what type of case is it? And in this case, it would be default with the written agreement. You'll see how there's the 3 options: without agreement, with agreement, and uncontested. Uncontested being when a response is filed. So let's talk specifically about what the court considers to be the judgment or settlement agreement. It all means the same thing. Settlement agreement doesn't mean it has to be some type of written format. The forms, the combination of the forms, for instance, the 343 spousal support attachment and 345 property order attachment makes up your agreement. But you may say, well, we don't have assets or debts in alimony. Okay, that's the agreement. The 343 is going to say there are no assets in there is no spousal support, and whether you're terminating the court's jurisdiction or reserving jurisdiction. And that is a 3-page form, but it's very simple if you're just terminating, because you mark that you are stipulating at the top of page 1. Again, going off the top of my head, thankfully I've done this for 10 years. Stipulate at the top of page 1. You mark terminate on page 2, and that's it for the form. If that's what you're doing. Otherwise, you would fill out the box for reserved, or if there's going to be alimony. So that's the 343. On the 345, that's the property order attachment. And even if there's no assets and debts, there are boxes to literally say no community property, no assets, and no community property debts. If there are, you simply fill in those boxes, and that becomes your settlement agreement. So let me see. And so that really is it in a nutshell, as far as what the judgment package consists of. Now, let me go over some of the questions that you had in regard to these individual forms. So the question is, for my 141, does my name information, okay, so we answered that. Yes, your information will appear on that form. Since we are both filing 141s as preliminary documents, do we also have to include a final 141? So yeah, we already answered that. You do not need a final 141. The 144 will take care of waiving that for you, and you both will sign that. Okay, since 8C was marked on FL 100, will choosing something different on our agreement 170, 180, 343 be grounds for rejection? So that is a perfect question, and this is why I talk so much about the difference with default with written agreement versus default without an agreement. So if it's without an agreement, like if your spouse is trying to finalize this without you, they can make 0 changes to the petition. The judgment has to match identical, word for word, box for box, letter for letter. You can't make any changes whatsoever. And that can be very problematic if you wrongly file your petition. We had a client retain us because they filed their, and again, half our clients come to us where they've already started their divorce, and their judgment will get rejected, and we'll have to fix it. And many times where, say it's going to be a default type case and there's not an agreement, and they filed a petition. In this particular case, they marked reserved jurisdiction, and that was a mistake because they didn't want to do that. But we cannot turn in then a judgment when there's no agreement changing any of that. You have to amend your petition and start over. That's why I hate true default cases. I only take them where we're starting them from scratch and there's no assets, debts, children, and there's marriage of less than 10 years. And that's a whole nother rabbit hole, because by a default with no agreement, you cannot terminate the court's jurisdiction over spousal support, but on a default with written agreement, you can. So when it comes down to default with written agreement, you can do whatever you want. The only thing that would cause your judgment to reject if there was actual errors on the petition, changing, from reserved to terminated or vice versa is totally fine. But if you left out something technical on the form, like you missed the date of separation on the petition, you didn't list that, or you didn't put, how long the marriage was below that, or you didn't check boxes at all, like on the separate community property, if you didn't mark the boxes at all, that's something that will be a problem that you'll probably have to amend your petition. Same goes with adding properties. Let's say you marked no property, but now there is some property you want to list. You can do that by agreement. You don't have to amend your petition. Let me go through these other questions. Okay, so I know you mentioned it wouldn't hurt to include the 150 in the package, but not attached to the 165. So the reason I said it wouldn't hurt, so it depends. On the income and expense declaration FL 150, the courts don't require them unless there's minor children on these types of cases. So that's why I said it wouldn't hurt to file. It's not wrong to file it, but the court is they're not going to require it if there are no minor children, although it is required when there is minor children. But if you do file it, yes, do not attach anything to the 165 when you have a default with written agreement. All you're going to say is there's been no changes in the petition and some of the other form or boxes that may be applicable. Excuse me. Okay, so that handles that. So that was the questions we had and why I went into doing this video to see what other questions have come in since we started. And for those that are just joining us, if you have any questions about paperwork, court forms, your judgment's been rejected, you have some technical questions, that's why we're doing these today. Specifically, we're talking about the forms needed for a judgment when there's a default with a written agreement. And if you missed the beginning of this process, this will be available on the replay on YouTube. So, okay, here's another question that came in. Although you made it clear that a 141, 142, and 150 need to be filed for the petitioner, I'm unclear as to whether the 141 and 150 needs to be filed by myself. So yes, so just to be clear, the 141s get filed by both parties in a default with written agreement. The 142 never gets filed. That's just for disclosure purposes. And the 150s, you can file them, but they're only mandatory when there's minor children. So you would file the 141, and it's your choice on the 150. If you're having spousal support as part of your agreement, you may want to include the income and expense declaration. You'll also need, no, you don't need a spouse support calculation on spousal support. That wouldn't be required. So it's really your call if you want to file the income and expense declaration. The court told me the 330 is needed as proof that these were served in person. If you're talking about the 141, that is not true. The 141 literally says that those documents were served. You do not need the FL 330, which I believe, because we don't use those very often, as the proof of service by mail form. You do not have to include a proof of service. I've seen people doing their own cases where we've taken over and they had a proof of service on every single form that they gave their spouse. They do a proof of service on the income and expense, proof of service on the 142. That's not necessary. The 141 takes care of that. And you'll notice if you look at that FL 182 judgment checklist, though it doesn't say to do a proof of service on all of these. The only thing that needs to be served is the initial summons and petition. And with LA County, there's a case cover sheet, and that can be done in two ways: personal service. What we like to use is what's called notice of acknowledgement, and it's just something the respondent can sign without actually having to be personally served. So that was really it. Again, if you jumped on late and have some questions about anything related to divorce, the paperwork, the process, be happy to help you and answer those questions. Otherwise, if you were coming to watch this because you had a default with written agreement type case and you wanted to know what forms were required to file, keep in mind, I've also, if you go to our YouTube channel, we have a lot of these live videos, and we've even gone through an entire case from start to finish with every form you possibly could ever need to file. I want to say it went about 45 minutes. I just kind of went through initial petition all the way through final judgment, and you can find those videos there. And feel free to comment when people are commenting on this. I try and get in there and answer, and if it deserves another video, I will do another video. So without further ado, if there's no further questions, I appreciate, oh, here comes some more questions. All right. So I will hang on for those. But for those of you who tuned in late, judgment forms are 180, 190, 343, 345 at a minimum. If there's kids, there's a 341, 342. You also have the 165, the 170. Can you tell that I have been doing this a long time? So, you're planning on submitting via e-file. Okay, so I did a video on that the other day. I 100% suggest you e-file if you're in LA County. Right now, only of this stream, I was talking about how we are getting cases finalized in 3 days, especially cases that were older where clients called us, they're having rejects. We'll take over, fix their paperwork, have them sign and notarize. We e-file, and we've had one done in 1 day, 3 days. If they're a little bit more complex, it'll be, maybe 4 or 5 days, but most of the courts are very fast in the processing electronically, whereas if you're still mail filing them or dropping them off at the court, it's still going 2 or 3 months, which is what many of the courts are right now running. See, we have some cases up north, Contra Costa County, San Francisco, Stanislaus. where they're taking 3 or 4 and 5 months just to process their cases. They're very old school, and they've always been kind of problematic. So when you say attach forms, is it self-explanatory as how to do this? So when you go to do the e-file, I'm going to be doing a video on e-file. The only problem I'm having is when I open up my e-file system, it kind of shows all my clients, and I don't think they'd appreciate that. Not that anyone would know anybody, but that would be my luck. Someone would know, oh, I know so-and-so, and you showed their personal information. All this shows is a name and a partial case number. It's not even a full name. But that's what the workaround I'm trying to get. But I'll try and walk you through the e-file. Definitely spend the time to figure out how to do it. It's going to save you quite a bit of time to get filed. And you will get an electronic notice that it's been received. You'll get another notice once it's been accepted, meaning they've reviewed it partially and it's been accepted, and then it'll actually go for review. So you get updates, whereas if you mail it in, you just hope they got it. And back in the day when we had to mail these in, or at the time we'd had a attorney service drop them off, there's no acknowledgement that they receive it. They don't give you a receipt. And they would lose cases on occasion. So on the attachments, it's pretty clear cut. The forms, when you do the e-file, they're going to have the same name as the form. Sometimes they're a little tricky, so you may have to search around for them. Like the 141, if you put in declaration, it'll come up, and there's like 50 forms that say declaration. You just have to find the one that matches the form. Declaration regarding service of declaration of disclosure. So the trick on this is that, and I think what you're trying to ask me is, all of the forms will be uploaded separately, except for the judgment portion. So the 180, 343, 345, then your signature page. Behind that, the court doesn't give a page of, people always say, where do we sign? There's nowhere to sign on these forms. So just get out a Word document, a PDF or whatnot, put, judgment attachment, or, signature page, just put something at the top, put a place for a name and date of the petitioner, name and date for the respondent, and then a place for the judge to sign. You don't even need a place for the judge to sign, because on page 2 of the 180, that's where the judge will normally sign. Usually if we have like some type of settlement agreement terms, we'll do more of a written narrative and have the judge sign at the end. Sometimes they cross it off and sign on page 2 anyways. So it's up to them, but just have a page for you both to sign, petitioner, respondent, and then make sure that page gets notarized. So you're going to have your 180, 343, 345, the signature page, the notary. That will be uploaded as the 180. All of that's 180. So don't file the 343 separately, the 345 separately. Those forms combined make up the judgment. And what a big mistake is, people miss the page number on page 2 of the 180. So you'll have the 2-page 180, and then if you have 3-page 343 and the 2-page 345, your signature page, I'm counting on my fingers, and the notary, you're going to put 7. You won't put 9. It's how many pages following page 2 of the 180. Other than that, the 190 is uploaded separately, e-file. The 165 is a 2-page document separate. 170 is 3-page separately. Each 141 will be uploaded separately. Your 150s will be uploaded separately. So that's the only one you combine, is the actual judgment portion. And yes, so if your judgment is rejected via e-file, it is very much like, well, it's probably everyone's first rodeo. The judgment rejects what they tell you is wrong with it may or may not make sense. If it's a simple change where they'll say, you didn't mark box 1 on whatever form, that's pretty clear. But if it's if it is some type of language issue or something like that, they're just going to tell you some boilerplate statement like seek legal advice. It's pretty bad if there's a lot of issues. Kara, since we're talking a lot about your particular case, if you could just put in the comments, what are you guys doing? Okay, you said no spouse support at one point I saw. Has it been a marriage of longer than 10 years? Because if so, there's some special language you need to include in that. And I don't recall if we talked about that, or if maybe I had already sent that to you. before. If you can just plop that in the comments, because I can email that over to you. There is. So yes, I sent it to you, or yes, it's been longer than 10 years and you need the language. Anyways, you can always email me after the fact. So what I'm referring to is, if you've been married longer than 10 years, the court's rule is they will retain jurisdiction over the issue of spousal support indefinitely, which means there could be a potential request for spousal support at any time in the future. Doesn't mean it's automatic, just means that there's a potential for it in the future. Most of our clients who don't want spousal support now, even if they've been married longer than 10 years, okay, I'll get you the language, I'll email to you. It'll be easier for you to copy and paste. So, and this is one of the benefits of working with us, is these are just some things you would not know. So in that particular case, that's where I was telling you, they would have rejected your judgment, and they would have said something obscure like, look at in regarding marriage of Bomaka for trying to terminate your spouse support, and you would have, you would have no idea what that means or what they're referring to. You would Google that, and there's just some language in there, and it's kind of mean because you can't just say we agree to waive it. There's a whole, I think, 3 or 4 paragraphs of waiver language for that to happen. So going back to the benefit of default with agreement versus default without an agreement, if your spouse is trying to, or you're trying to do a default no agreement case and with a marriage of longer than 10 years, you cannot terminate spouse support. You have to reserve jurisdiction. Now, let's say you filed it as terminate on the petition on a marriage of long duration and doing a default without an agreement, and then you turn in your spouse support order with your judgment saying no spouse or terminate spousal, your judgment will get rejected because you can't do that on a marriage of longer than 10 years unless there's an agreement to the alternative. So always talking about why default with written agreement is the way to go. People think, and every time, I shouldn't say every time, 99% of the time when people call me and say, hey, Tim, my judgment's being rejected 3, 4, 5 times. And this happened probably 5 clients last week. And 3 of them had attorneys. If you go see on my YouTube channel, I keep doing videos on this. 3 of them had attorneys. They were amicable. They just decided to use an attorney. I guess they didn't know, lower cost options are available like what we offer. But they were, again, trying to push through these cases as default without a written agreement. And this one attorney had this client's case rejected 5 times before they called us. And we fixed it in about 2 hours and had them sign, notarize as an agreement versus no agreement. And it went through just fine. And we just finished them up on, I think, Friday. They were complete. So it's the biggest difference, default with written agreement. I think we've covered quite a bit. I think more than I intended, but it was all good stuff. Again, go in a lot more videos on our YouTube channel. If you check the shorts, we have little quick blips of information. The longer videos, we've tried to title them, the live videos rather, we've tried to title them to be specific of what they are. And keep in mind, some are 20, 30, 40 minutes. You can scan through to see the different form completion. You don't have to watch things you've already completed, but you can kind of just, if you scan over the bar, you can see where that form is being completed, like especially on the video we did on completing every form start to finish. So one last chance to get your questions in, folks. And we're trying to do this as frequently as possible. I tried to do it daily for a while, and I think I made it 3 days. It's quite a bit of setup on the back end and creating thumbnails and setting up on all the different platforms, because we are on, not just YouTube, we're on LinkedIn, Facebook, Twitter. We're trying to send this everywhere. You're welcome, Kara. I'll get that language to you. If I forget for some reason, why don't you just shoot me an email so I can get that to you. And though what you will do is just copy and paste that into, is it MC030? Give me one quick second here. There's a, just copy and paste it into a form. No, not declaration. 5 attachment. Yeah, MC, M as in Mary, C as in Charlie, -025. Just the language I'm going to send you, just attach that into an MC025. It's just an additional page form, and put it right behind your 343. So in your particular case, it's going to be 180, 3-page 343, the MC-025 with the language I'm going to send you to terminate spouse support. And you guys need to, there's some initials you'll see that don't forget the initials. You have to initial off on it. Then your 345. So you're going to have 8 pages. So you need to stick that in there. And that should take care of that for that particular case. Again, keep checking back. We're trying to do these where we give a specific topic like today with the judgment forms for default with written agreement. And then we kind of hang out for answering questions that come up during the broadcast. So looks like we're at about 30 minutes. I don't see other questions coming in, and we will talk to you guys soon. Let everyone know that we're here for help. And if you're having trouble with the Self-Help Center, we'd like to give you the correct information and get your cases done, even if you're not using us for our full service solution. We'll talk to you guys soon. It was a pleasure helping you, Sarah. Anything else comes up, just shoot me an email, and I'm happy to take care of that for you. Talk to you soon.